Easy payments and deposit reconciliation. Try it with LawPay plus QuickBooks Online. You shouldn't have to waste valuable time getting paid for your hard work. Simplify your day with LawPay, an affordable online billing solution that allows legal professionals to quickly and securely accept payments. Now integrated for seamless workflow, you can automatically upload your LawPay transactions to your QuickBooks Online account. With easy transaction reporting and accurate deposit reconciliation, your firm will be equipped with the best tools in the business to help you do what you do best. Schedule a demo to learn more at lawpay.com/demo.
Welcome to Brief Encounters. My name's Kady Ashley, and I am an M&A partner at Skadden in the DC office. And I'm here today in my capacity as a co-chair of the M&A subcommittee of the Corporation Finance and Securities Law community, and very pleased to be joined today by Madison Eggert-Crowe, who is the Vice President of Political Affairs at Comcast, and Ki Hong, who is my partner at Skadden in DC and head of our political law practice. And today we're going to be speaking about political law in the M&A context, since this is an area of law where a lot of us M&A practitioners don't necessarily spend a lot of time thinking about what the repercussions for a transaction may be with respect to certain political law issues. And I think in my experience and in speaking with Ki about these issues, we've learned that sometimes they can creep up as unpleasant surprises close to signing or even at closing or later. So the idea today is to give you all a little bit more information about the things to look out for, the kinds of transactions where political law issues may be particularly acute and how you might approach them, and then to benefit from some of the experiences that Ki and Madison have had over the years shepherding transactions through various phases, and Madison in particular in terms of integrating a number of different businesses into a very large corporation with a sophisticated political law practice. So with that, Ki, I think I will start with you and just ask you to sort of set the stage for us, give us a little bit of the legal background on pay-to-play, perhaps to start with, and tell us why this is something important as M&A practitioners to know something about.
Well, I think the first question when we talk about political law implications in an M&A is define what we mean by political law. And there are various different types of laws that we deal with, but to kind of generalize, these are laws that regulate a company's interactions with the government, whether it involves making political contributions, lobbying, or government procurement where you're trying to obtain a state investment or a state contract. The reason that this area is becoming more of an issue in the M&A space is that these laws have become more draconian in the last decade or so, where even footfalls, no matter how benign the activity is, or especially in the pay-to-play space, which we'll talk about first, where no matter how benign the footfall is and you make a political contribution, it could lead to an automatic ban on the company's ability to enter into state contracts. The longest we know of is 5.5 years, and it's just automatic. It doesn't matter how benign or how bad the fact pattern is regarding the contribution. One theme that we're going to be talking about, and we'll keep coming back to this, is that these laws push a company to centralize the compliance function in these areas because the scope of the coverage of these laws, et cetera, it kind of forces centralization. And, as you know, Kady, in an M&A context, it's already a challenge trying to meld the cultures of the two companies if you are merging or acquiring a company, and then you add this to the mix, it can become really challenging. So the pay-to-play laws is kind of the highest risk issue in this space. What a pay-to-play law is that these laws at the state level started back in 2005. It was with Connecticut and New Jersey. They were the first ones to create their own pay-to-play laws. And what these laws say is that to the extent either the company, its affiliates, their PACs, or even if various executives and family members and even board of directors, if any of them contribute to a candidate like a governor it triggers an automatic ban on the company's ability to enter into government contracts. Now, these contracts can be huge. I mean, I've seen contracts in the financial space where it's literally $90 million a year at stake. And as I mentioned, the implications are automatic. So, and we've had executives one executive who was given to his mother-in-law, who was running for county office, an automatic ban applied. And under that rule, there was a waiver proceeding and the government denied the waiver in giving us a waiver from that ban. So these are automatic. So it started in 2005. The number of states now, it's well north of 20. And there are literally dozens, and if not hundreds, of city and county pay-to-play laws that work this way. For those in the audience who are financial institutions, there are various federal pay-to-play rules that apply to contributions in all 50 states. So you have Rule G37s for the broker-dealers that underwrite muni bonds, SEC Rule 20645 for investment advisors that manage government money. You have FINRA Rule 2030 for placement agents, and then finally CFTC Rule 23.451 for the swap dealers out there that are entering into swaps, and the government is the counterparty. The various implications of these pay-to-play rules in the M&A space is that, first of all, we've seen this impact the valuation of the target, where the company thought they had the right valuation and the offer on the bid. And they find that the company has a slew of state and local contracts, but has no compliance program to deal with these pay-to-play laws. And it really can, if it's a target with a lot of government contracts, it can really affect the valuation of that target. The other implication we've seen is that in an M&A transaction, the acquirer can inherit the ban that the target has made before the acquisition. And so if you essentially merge that target into your company, you're essentially inheriting the ban that they have. And by the way, the target may not have cared about state and local contracts, right? I mean, but by inheriting their liabilities, you're inheriting the ban, and the acquirer may care a lot about state and local contracts. Then finally, we have kind of the impact going forward. You're melding two companies together, and one may have a certain approach to contributions and the other one, and they may be very different. And as I also mentioned, one company may not have cared about state and local contracts and the other one does. How do we deal with that centralization? And Madison, I know, with especially a large company such as yours, one challenge has been that many of these laws cover contributions by affiliates, right? So if you have 1,000 affiliates, for example, a contribution by one of them would trigger a ban on the other 999. And, what kinds of challenges have you seen in that space?
Yeah, I mean, I think that's right. And I think that, the point that you made about centralization being incredibly important in this space is so true. And I think sort of just generally, because all of these sort of areas of political compliance just interact with each other and sort of impact each other generally. But to your point about sort of affiliate contributions impacting other affiliate contracts is just really important to keep in mind. That sort of the way that we handle it is that any contribution that sort of an entity in the company wants to make, a political contribution, it's approved by a centralized team. And sort of the way that, that the centralized team can sort of look at it from a global perspective and think like, hey, this entity wants to make a political contribution, but this other entity wants to enter into a contract. How do you sort of look at those considerations to maybe say, hey, this entity shouldn't make this political contribution because this other entity has a contract or wants to enter into a contract? And that's obviously sort of challenging in the, especially if you've just sort of acquired a company and they may be used to making contributions freely and not have to, like you said, Key, not have to sort of consider the state and local contract implications. That centralization is really key from day one. So you need to ensure that sort of you're looping in the sort of new company, employees into your policies about pre-approval for these contributions, centralizing it, even when it's challenging culturally to do so, to sort of ensure that the sort of the new company is going to seek pre-approval for certain contributions before they make it, so that you can consider these, the contract implications, as while it's really challenging, is really important just from a pay-to-play perspective.
And it sounds like even before you're getting to the integration phase, it can be really critical from an M&A practitioner standpoint to do the right due diligence on the target, depending on the kind of company it is. And then just importantly, the kind of company that you are. So your target might be an entity that really isn't, as Key said, interested in entering into government contracts, so may not have really thought about a compliance program in this area. And then you're bringing them into your company where that's a critical issue and it affects so many other affiliates. And I think a lot of times this might be something, it's not a top of mind for a lot of us who don't live and breathe this every day. Key or Madison, do you have any tips for, what you might look for in the sort of initial due diligence phase, how you might approach it with a company, for example, that maybe didn't put a lot of time or effort into a compliance program, what you might be able to do even before you enter into that agreement to see if this is going to be sort of a fatal issue for you?
When looking at the target and doing the diligence, I find half the challenge is to convince the target this is a real issue. And you have to do it very gingerly, because the last thing you want to do is accuse the target's compliance group of having dropped the ball, right? Or not having considered something that they should have considered over the past years. And it's surprising because, we've diligenced a good number of targets in these transactions, and we find that there are actually active certifications they signed that they had not contributed, but there was no compliance diligence that went with that certification or was the foundation of it. And so that's, I think, half the challenge here.
Yeah. And I mean, I think just sort of generally, I think it's sort of important to just sort of understand the target company's approach to this activity generally. Are they making contributions? Do they, engage in this activity? Are their executives making contributions? And sort of just knowing their approach to political compliance and what their program is like is just important generally. So because it's going to impact sort of how you interact with them post-transaction if you even get to that phase. And I think just, it's also just important to know sort of to your point, Kady, that this isn't something that necessarily others in the M&A space are thinking about, right? It's important that you bring in the political compliance folks at your company at the right stage so that they can think about these implications too, right? Where are we making contributions? Where are we active from a contracting space? I think those are questions that we need to be asking at the right stage so you can think about sort of how the transaction is going to move forward.
To add an added layer of difficulty or challenge here, as I mentioned, these pay-to-play laws cover a bunch of individual contributions as well. It can cover your senior officers, your board members, those employees who are out there interacting with the government, trying to get the government contracts, and even their family members, their spouse and dependent children under a good number of these laws. Now, just a question for you all, is one thing to say, okay, you guys can't give corporate money, but how does that play when you actually tell them you can't give personally either, and neither can your spouse or your dependent child? And I could imagine that raises some feathers here.
Right. And I think that a lot of that sort of will depend a lot on sort of what the company's activity was sort of pre-transaction, right? A lot of times, like you said, Key, this is going to be new to a lot of them, right? The restriction on what contributions they can make. And because it's so important to communicate that from day one, it's going to be a challenge sort of to communicate that, right? To make sure that these executives understand the restrictions on their personal contributions. We send a memo to the sort of covered donors to ensure that they understand restrictions on personal political contributions. And sort of, if you have to loop in new executives into that type of program, you have to make sure you have the right covered employees, right? And that could be a challenge with a new company to ensure sort of, who are the covered employees, who is going to be sort of a covered donor under these certain pay-to-play laws that you were mentioning, Key. And then the other company might have a different culture in how they communicate with their executives. They might, want to have an in-person conversation versus a memo, or they might want to sort of limit how they communicate about certain things like this. But no matter what, it's important that these restrictions are communicated. So you have to make sure that you are communicating them and doing it quickly so that that these employees understand it. And again, you have to also, to your point, Key, be able to communicate why you're doing this, right? That it's not a restriction on you don't want to control what personal contributions they make, but you need to do it from a pay to play sort of compliance perspective to ensure that you can continue to contract in certain jurisdictions. And being able to communicate that is really important when it comes to executives.
Yeah, I can't tell you how many executives I've heard complaints and essentially accuse the new company of doing this to out their political affiliation. They'll say, "You're really doing this to find out whether I gave to a Republican or Democrat, aren't you?" And it's really hard to overcome that assumption there.
Well, and then you have the situation where, you had somebody you plan to bring in at a certain level in the integrated company at an executive level, and that might be a level that would be, caught up in certain pay-to-play laws, and you find out that they have a contribution history that would then have a consequence for the acquirer if they took on that executive role. So, it can become a very personal issue for individuals who were counting on certain post-closing roles if all of a sudden this, $500 contribution in New Jersey is what may keep them out of a C-suite role.
Yeah, and we've seen this play out numerous times where the head of the target, you will a lot of times move her up to like a C-suite position in the new acquirer entity. And, she may have been a political operative before the acquisition, and they really couldn't have cared about pay-to-play law. And now we're telling this individual, all those efforts you've made to become an active political player because you care personally, all of a sudden you can't do that anymore. And that ends up in some very challenging conversations, as you can imagine. So, so that's pay to play. And I think that's probably the biggest risk in the M&A space. Equally challenging, but not as the stakes are a little lower. We've also seen this in the context of lobbying compliance. Every state and the federal government has a law that says that if you're trying to influence a covered government decision, which could include just your traditional government affairs type work, where you're trying to influence legislation, where you're trying to influence rulemaking. But 32 states now and the federal government also includes efforts to try to get government business or government contracts. That's considered lobbying as well. What happens under these laws is that it triggers a requirement on the employee's employer, the legal entity that employs the individual. It requires that entity to register and report under the lobbying report. And these reports usually make you disclose the amount that the company spends on lobbying. So you add up all the employees' time that went toward lobbying, and you have to include that. You usually have to disclose gifts and entertainment to public officials, which in many cases, there are strict limits on that, and you may have to disclose a violation sometimes, which is not the best position to be in. And it requires you to disclose the issue you're lobbying. Now, because these laws go entity by entity, there is an interest on the company to try to consolidate all of that lobbying, at least in that jurisdiction, to one legal entity. So I can't tell you how many times, in a transaction where I've worked with clients to move all of their federal lobbyists, for example, into one of the company's affiliates or the parent company, so that we don't have to register and file for numerous different affiliates, which can be a nightmare under these laws. Again, another reason that these laws kind of push toward centralization of these functions. Madison, what have you seen in that space? Especially, I know you guys have companies in different, I know it's all communication and entertainment, but not all affiliates are the same, and having to bring all those lobbyists into a central entity. What have you seen in that space?
Right. Yeah. I mean, we had to, to your point about sort of consolidating the employer of certain lobbyists, we've had to go through that ourselves and sort of at the federal level, so we can sort of keep just one entity registered. And, that poses some issues, just both logistically and from a company culture perspective, right? So logistically, you need to ensure that HR is able to, ensure that those employees are hired by one of, the one registered entity at the federal level, but then they have to do so moving forward. So, if you're hiring someone that would have been employed by an affiliate, needs to be employed by the registered entity, you need to ensure that you have the right processes and procedures in place to actually make that happen. But then from a company culture perspective, is sort of especially if this is sort of immediately post-transaction, right? You might have you're bringing over employees who would were engaged in federal lobbying at their previous company that was acquired by your company, and now they need to be moved over to be employed by the registered entity. While they sort of have loyalties to or more affiliation with the acquired company, that just sort of creates a little bit of a company culture clash. And you have to be able to, one, communicate why you're doing it, communicate that it's important that we're registered under one entity so we can report that way, but then also sort of find other ways that they can feel connected to the other entity. But it is a challenge sort of logistically and culturally. And then sort of at the state and local level, I think it's a little bit of a different animal, right? So maybe if you're not sort of consolidating the companies, you're going to have sort of two operating entities and they might be sort of overlapping in certain jurisdictions. You might not take that federal approach and consolidate the employer of those employees, but that might mean that you might have two separate entities registered to lobby in that jurisdiction. You have to think about what the implications of that are, right? But sort of you're going to be taking potentially two different approaches at the federal level and the state level, depending on the activity, depending on sort of where you need to be registered. And I think it's just, again, that centralization is important because you need to sort of have that global view of the activity to understand how to approach it and how to approach sort of the reporting and the oversight of that activity.
So if I'm thinking about this correctly, it sounds like pay to play, we probably wanted to focus our diligence earlier in the process because that can really impact valuation, either of the target or what happens at the parent company once you bring the target on board with respect to government contracting in either case. And lobbying, it's sounding to me like it's more of an integration issue. How do we bring these two different teams together? So it's probably not something that we have to put high on our diligence radar as much early in the process when we're sort of negotiating a deal, trying to decide whether we have a deal here. But it's more of that sort of between signing and closing period when we figure out how we're actually going to close and integrate these companies. For the non-political law person in the group, am I thinking about the distinction between those areas correctly?
Yeah, I think this is not a diligencing question necessarily. It's getting everyone ready to, at least that everyone's aware that this integration is going to have to happen. So I don't think you need to have all your ducks in a row, but you do need to know there's some ducks. You do need to know that you're going to have to line something up in this space because if just after the transaction and everything's closed, you go up to the target and say, okay, we're going to take all your lobbyists and we're going to move them to us. That's a pretty threatening message you're giving to the target, right? I mean, in the target's mind, they're not thinking, oh, they're doing this to streamline compliance. In the target's mind, they are doing it, to take away our power or, take away our voice. Autonomy and our voice in the lobbying in the government affairs space. So one thing that we had a good number of clients do is to kind of ease that concern. They would essentially say, look, we're going to take your lobbyist and they're going to work for us. They're going to become our employee, but they'll have a direct line to you, not a supervisory line, but they have a direct line of communication. They're the ones responsible for business issues that arise for business X, which is your business. And, this other employee is going to be responsible for GR issues regarding business Y. That's one of the kind of solutions I've seen to address this difficulty.
And I think sort of from a contribution perspective, Key, another way that you might alleviate some of that, concerns about the centralization and the coordination is think about ways that you can sort of help do some of this research up front, right? So maybe it's from a campaign finance perspective, finding out where affiliate contributions are aggregated or where your contributions could impact their contracts and vice versa, and sort of do that up front to help communicate that, to help encourage that collaboration and understand that, hey, we can be in this together and we can help each other out with just sort of the communication. I think that helps alleviate that stress a little bit too.
Great. And trying to limit the activity that you're trying to centralize. That is an area we've seen companies go. The last thing we should touch on because I know our time is almost up here, are PACs, political action committees. And It's not as challenging if if only one of the companies has a PAC, but a lot of times, there are two companies that have their own political action committees. And for those of you in the audience, the political action committee is essentially a political organization that a company sets up that's funded by their employees and makes political contributions, whether it be at the federal or state level. And kind of the drive towards centralization there too, right? I mean, it really doesn't serve the interests of the new merged company to have two PACs. It confuses the message usually. The officials don't know where the contribution's coming from if you have two PACs and things like that. What kind of challenges have you seen in consolidating PACs? Because I notice people take their PACs very personally. They have kind of like, that's our PAC, you can't touch it. I know there's that kind of dynamic sometimes.
Yeah, I think this is sort of, again, where you sort of have this company culture concern and where you have to sort of alleviate the pressures there. And when it comes down to, are you going to consolidate the PACs? Or are you going to have two different PACs, right? Most likely you're going to sort of create one PAC, and it's figuring out how are you going to communicate about that PAC? How are you going to name the PAC? Because it's hard enough for companies to fundraise for their PACs generally, and to add this added layer of, adding in new employees who are eligible for the PAC. How do you communicate about that is just challenging. And I think just sort of over communication, sort of being upfront about what the changes are and communicating sort of the benefits of joining the PAC, you just sort of have to get through it and over communicate and loop in the right people to communicate that message. It's a challenge, but I think it's just really important.
Yeah, I think the worst case, I had one transaction where this challenge of melding the culture was particularly difficult. And what they did there was, instead of just merging, what you would usually do is take one PAC, merge it into one of the existing PACs, and then change the name of the existing PAC. That's what you would usually do. But to satisfy everyone, in that case, we had to terminate both PACs and create a third brand new PAC, just to tell everyone, look, this is a brand new thing. We're not, no one's
Right.
winning in this deal. We're all kind of equals. So I remember they went through that extra legal expense and headache of doing that just to make sure everyone felt okay with the consolidation there.
Yeah, I think we've all seen challenges like that, especially in the merger of equals space, and how you keep everybody happy and content that it really is a merger of equals. Well, I think that about covers it for a brief introduction into the very scary topics of political law that we M&A practitioners may have been ignoring. So there might be a few moments of lost sleep from the audience here, thinking about what we maybe haven't been paying attention to and need to pay close attention to in certain kinds of transactions. And I want to thank you, Madison and Key, for joining me today and taking the time to provide this really valuable information to our M&A community and others. Thank you both.
Thank you.
Thank you.
This episode of Brief Encounters was brought to you in part by our sponsor, LawPay. Schedule a demo at lawpay.com/demo to see why LawPay is trusted by 50,000 law firms.